Telling you the latest in the mega Essar steel case. Disappointed with the most recent NCLAT order that changed the waterfall in favor of the operational creditors post the verdict, the secured lenders were poised to recover nearly 30% less. The banks have already appealed, and now it seems that the Ministry of Corporate Affairs will do the same. This wing of government wants to ensure that the secured lenders do not lose out and wants to ensure the spirit of the law. My colleague Ruchi Bhatia is on top of that story and now joins in with all the exclusive details. Ruchi, fill us in with the latest.
So, Aman, we are given to understand that the government may intervene after the recent NCLAT order in the Essar case that ruled that creditors whose claims were backed by collateral will not get any preferential treatment in the $6 billion sale to ArcelorMittal. Now, we're given to understand that Ministry of Corporate Affairs is working on various options to ensure that operational creditors and financial creditors are not given the same status, and the spirit of the Insolvency and Bankruptcy Code is maintained. Now, remember, big cases like Essar Steel, case will also impact cases like Ruchi Soya, which are already in the courts. We're given to understand that the Ministry of Corporate Affairs is looking at two options. Among the two options that they have with them to assure financial creditors are given preference in bankruptcy rulings. Option one is that MCA may either implead in the Supreme Court, emphasizing on the rights of secured creditors, given the fact that the lenders have already reached out and knocked the doors of the Supreme Court. Option two is the MCA that may give clarity via amendments to the IBC. As I told you, these options are on the table. It is being discussed at this point of time. The government's view is very clear that the intent under the Insolvency and Bankruptcy Code is very clear, that financial creditors come first, followed by operational creditors. And they believe that the NCLAT ruling goes against the spirit of the Insolvency and Bankruptcy law.
Okay, right. Okay, Ruchi, just run us through also in terms of, the fact that this is now going to take a new turn. Does that mean that things will come to a standstill? Is there still any other legal action that can come in from the other side? Like, what really happens next?
So we are given to understand that, remember, the lenders had already reached the Supreme Court, knocked the doors of the Supreme Court in this NCLAT ruling that basically put the financial creditors, the operational creditors at par. What the lenders were essentially saying is that this puts the entire IBC process in jeopardy. It unsettles the current settled principles of the IBC law. And which is why we're given to understand that now the Supreme Court in their, they're going to take up this case tomorrow. They will be hearing the pros and cons of the argument that of course, the lenders have, and if needed, the government too will be intervening in this matter. This is going to have a long-term impact on the nature of the Insolvency and Bankruptcy Code in India. Remember, the IBC rulings in many cases are a test case, so to say, and which is why the government wants to make sure that the law is right in its spirit, and which is why the government may look at impleading in the Supreme Court.
Thanks very much. And remember, there have been lots of twists.